Oh, okay. Present are Commissioner Herndon, Booth, Pena, Baker, and I am Chairman Rodriguez. Welcome to everyone. It is approximately 7:03 p.m. Thank you, Ryan. That was agenda item 1. Agenda item 2, the time is approximately still 7:03 p.m. Consider approval of the September 3rd, 2019 zoning meeting minutes. Does anybody have any comments in regards to those minutes at all, or anyone? We will accept a motion if someone would like to bring one forward.
I so move.
Second? By Commissioner Booth. First was by Commissioner Baker, second by Commissioner Booth. All in favor? Unanimous?
Chairman, thank you. This actually gets us totally caught up on our zoning minutes, so
Okay,
completely. So thank you.
okay, sure, thank you. The time is approximately 7:04 p.m. Agenda item number 3. Public hearing and discussion on an application from the Wayside Chapel Evangelical Free Church for an amendment for a special use permit, SUP, granted on March 2011 to add property located at 113 Ivywood Circle, legal description CB 5007B, Block 3, Lot 3, to the property included under the SUP.
Chairman Rodriguez, ladies and gentlemen of the Zoning Commission, my name is Scott Fairman. I'm here on behalf of Wayside Chapel along with my colleague, Bianca Zuniga, who is handing out your information for you. That'll be on the PowerPoint as well, but I wanted you to have it in front of you. First, I just want to talk a little bit about the church. For those of you who don't know, the church has been a part of the San Antonio community since about 1960, so approaching 60 years. Been at its present location here in Castle Hills since 1987. And the church is involved, as you might imagine, in a number of different ministries intended to help the community, intended to help those that are disadvantaged, those that are suffering, and a bunch of different areas. And if you go on to the next page, I want to just give you a little bit of history of Wayside's contributions to the city of Castle Hills. For about 15 years, in recognition that the city does provide services to the church, valuable services, the church made a monthly contribution of $900. That totaled to over $132,000 contributed. Obviously, the church did not have to make those contributions, but chose to do so. Over $132,000 over about 15 years. Additionally, more recently, the public road, Ivywood Circle, was in need of repair. There was some pooling issues, drainage issues. Obviously, that's a public street, the responsibility of the city of Castle Hills. The church undertook it on their own to repair that at the cost of about $31,000, and also worked on, at their own expense, some drainage issues that were present in the alleyway behind 107 Ivywood Circle and 109 Ivywood Circle. So those were expenses in addition to the $31,400 spent on Ivywood Circle itself. So that takes us to the next slide. So this is about ordinance number 1069. Back in March 2011, Wayside applied for a special use permit for Ivywood Circle addresses 100, 102, 103, 104, 105, 107, 109, 111, 115, and 117 for church purposes. and that special use permit was granted in March of 2011. If you look at that special use permit, it has some specifics about some of the properties. For example, the properties at 103 and 105 Ivywood are used strictly for residential facilities for visiting missionaries. The other properties are used for religious education, religious meetings, instruction meetings, religious gatherings. And the SUP provides that the churches can only be used for church and religious purposes. The SUP further provides that the church can't remodel the interior or the exterior of those properties without the city's consent. And it's important to note that Wayside has fully complied with all the requirements of ordinance number 1069, which is the SUP issued in March of 2011. That takes us to the next slide. This is ordinance number 1111. In the fall of 2013, Wayside requested an amendment to the special use permit issued in 2011. The purpose of that was to grade and pave and stripe parking spaces for 107, 109, and 111 Ivywood Circle, and the construction of grass detention ponds to improve the drainage at 100 and 102 Ivywood Circle. And that amendment to the special use permit was granted by the city. Next slide. So if you look at that slide, if you turn back, it's in color, a little easier to see, although you can't see it on your handout. The properties that are marked in red are properties that are already included in the special use permit 1069. And the property marked with the orange star, which is 113 Ivywood, is the property that Wayside is requesting be added to the special use permit. Okay, next slide. This pertains to the City of Castle Hills Zoning Code Section 31.400. Ivywood Circle is located in a category called A, Single Family District. Under Zoning Code Section 31.401, the use of a church in this A category Single Family District is permitted under that section of the Castle Hills Zoning Code. That takes us to the next slide. And this is the section of the zoning code that deals specifically with special use permits. And section 31.1700 specifically grants authority and lays out the procedure for the granting of special use permits. And that procedure is filing an application with the city manager with site plans drawn to scale showing certain enumerated items. I'm taking language right out of the zoning code. The city manager shall then file the application and report on the application to the zoning commission, and then the zoning commission shall then conduct a public hearing and make a recommendation to the city council. The requests for an amendment to a special use permit go through the same process pursuant to the terms of this section 31.1700. And just to give you the history of this particular application, Wayside filed its application on April 3rd, 2019. On May 7, 2019, the Zoning Commission held a public hearing regarding that application and recommended that the amendment to the special use permit be approved. On August 13, 2019, the City Council voted to send the request back to the Zoning Commission based on a clerical error, and that was an incorrect street address. Let me take note here that that error was made by the City of Castle Hills, not by the church in its application. That takes us on to the next slide and the next page in your handout. So I'm going to just recount a little bit of some of the events that occurred or some of the happenings at the May 7, 2019 hearing. At that hearing, the City of Castle Hills City Attorney, Mark Schnall, made the following comments, and I will quote him. "I think that the commission can approve the special use permit. A church use is a permitted use in an A district. There are reasons why, under the current circumstances, the permit should be approved. When 2 prior special use permits have been granted, including the property on either side of the property in question, for the same use Wayside is now requesting, it would be inconsistent to deny this special use permit." Those are the words of the city attorney, Mr. Mark Schnall. There has been an argument raised that City Ordinance number 50-497 should be relied upon to deny the request for an amendment to this special use permit. That ordinance, 50-497, does not provide for a church use. Next slide, please. This ordinance, 50-497, was amended on September 12, 2007 to allow day nurseries, preschool, or kindergartners for permitted uses within this ordinance 50-497. That's inconsistent with the City of Castle Hill Zoning Code Section 31.401, which expressly allows a special use to be permitted for church use. And now I'm going to go a little bit into a little bit more of the legal aspects here. There is a federal law adopted in 2000 that's called the Federal Religious Land Use and Institutionalized Persons Act. That piece of legislation, that law, is typically referred to as the Religious Land Use Act. That takes us on to the next slide. The First Amendment of the United States Constitution says that there shall be no law respecting an establishment of religion or prohibiting the free exercise thereof. So over the years, Congress has passed a number of laws to ensure that Americans are able to exercise their religious liberties. This law that I referred to that was passed in 2000 was aimed at that very thing. Next slide. This federal law says that while zoning is primarily a local matter, where it conflicts with federal civil rights law and such as this 2000 federal statute, federal law takes precedent. And to give you a bit of background on that law in 2000, that law was passed as a result of voluminous testimony from churches across the country about local governmental bodies passing zoning laws, passing land use laws that burdened their ability to exercise their faiths. So this Religious Land Use Act, as it's referred to, protects religious institutions from unduly burdensome or discriminatory land use regulations. In addition, this statute specifically provides that where a church is being discriminated against by a local or even state governmental entity, that the church can petition the United States Department of Justice for assistance in these matters. So the Religious Land Use Act is intended to protect the exercise of religion. This next slide talks a little bit about how that is defined. That is defined as things such as Sunday school classes, religious education, meetings, gatherings, all of those type of things, whether or not they are compelled by or central to a system of religious belief. As the courts, these would be federal courts, have interpreted this 2000 piece of legislation, they have found that this, quote, religious exercise, the exercise of your religion, covers a wide range of activities, including operation of faith-based social services, accessory uses such as fellowship halls, parish halls, and similar buildings, rooms used for meetings, religious education, operation of a religious retreat center, and religious gatherings. Next slide. So these are just a couple of the pertinent provisions within that federal law from 2000, the Religious Land Use Act. It bars, in other words, it makes illegal any land use regulation that impose a substantial burden on religious exercise. Religious exercise is defined as those activities I was just describing a moment ago. And the legislation, the law further requires that the government treat houses of worship as favorably as non-religious assemblies. That religious assemblies must be treated at least as well as non-religious assemblies and institutions. This is called the equal terms provision. So let me go on a little bit further. So again, we're still talking about this 2000 federal law, and it protects against non-discriminatory conduct or discriminatory conduct that imposes a substantial burden on religion. So a religious organization does not have to show, according to the case law, that it was targeted by a governmental group. There is further case law that says when a religious organization buys property reasonably expecting to build the church, governmental action impeding the building of the church may impose a substantial burden. When a substantial burden is imposed, the government regulation is generally not upheld. And I'll just remind you that Wayside's been operating under this special use permit since 2011 and has complied with all of the terms of that and all of the additional terms that are set forth in the City of Castle Hill zoning code and other related ordinances. Okay, next slide. The statute says that no government shall impose or implement a land use regulation in a manner that treats a religious assembly or institution on less than equal terms with a non-religious assembly or institution. This ordinance that I quoted a minute ago, the City of Castle Hills Ordinance 50-497, allows day nurseries, it allows private country clubs to ask for and apply for a special use permit in all districts, including District A. But it prohibits religious institutions from even applying for a special use permit. The application is not even permitted. That's clearly in violation of the 2000 Religious Land Use Act. And then let me just talk briefly about a case from San Antonio, a federal case, just in the last 10 years or so. I think the final decision was only about 6 or 7 years ago. I'll make it short. The City of Leon Valley adopted some zoning regulations that essentially prohibited church use after a church called the Church of the Rock already owned a piece of property. So the Church of the Rock sued the City of Leon Valley. This case went all the way up to the Fifth Circuit. Just to help you understand what that means, that's the appellate court for the state of Texas, the federal appellate court that is one level below the United States Supreme Court. So when you have a decision at the Fifth Circuit, you take it to the U.S. Supreme Court if you want to appeal. So here is what the Fifth Circuit Court held with respect to this Church of the Rock's litigation against the City of Leon Valley. The court found that the ordinance was invalid because it prohibits a church from even applying for a special use permit when a non-religious private club may do so. And now let me quote. At bottom, the ordinance treats the church on terms that are less than equal to the terms on which it treats similarly situated non-religious institutions. We conclude, therefore, that the imposition of the city's ordinance violates the Religious Land Use Equal Terms Clause. Obviously, that's very, very similar to the situation we have here. Because under Ordinance 50-497, non-religious institutions can apply for a special use permit in District A, but under that code of ordinance, inconsistent with the zoning code, they can't. And let me just note that, once again, the church owns 11 of the 12 properties on Ivywood Circle. 10 of the 11 are part of and covered by the special use permit that's in existence. 2 of the properties, as required by the special use permit, are used to house visiting missionaries and no other purpose. The other properties are used for educational and church administrative purposes. The addition of one property that is in between 2 properties that the church already owns and are covered by the special use permit is not going to have any material effect on any of the criteria that are set forth for denying a special use permit that I've listed there. happy to answer any questions.
If I could, normally when people approach the podium, we ask the resident for their address, et cetera, to identify themselves. I just wanted to clarify, the capacity you're in here is representing Wayside Chapel as Attorney
legal counsel.
Fairmont and
I'm
Attorney
their legal-
Zuniga, or what?
I'm here as their legal counsel, and so is Bianca Zuniga, both of
Okay.
us.
All right, but you happen to be giving a presentation also, as their legal counsel?
Correct.
Okay. All right. Anybody have any questions? No? Just to
do.
share with you, okay. Commissioner Baker?
What do you estimate the substantial burden to Wayside would be if the application is denied?
Can't use the property.
Pardon me?
They won't be able to use the property.
And the plan is that, what have they been doing with it since they've owned it?
They haven't been doing anything with it.
Okay?
Because
And
it's not a part of the special use permit, they're not permitted to do anything with it.
correct. I feel very loud, sorry. Part of my issue is that I don't believe the special use permit is appropriate to be amended to add new property to it. You could amend it if you need to change light bulbs, other things like that, because that's not adding another piece of property to the use that's under the special use permit. So my objection all along has been that I didn't believe you could simply amend your application because special use permits run with the land. That's my understanding. And when you're adding something to it, that's not what the original SUP was about. And then in 2017, we did have a change. So between 2013 and 2017, there was no activity. So I don't see that there was an effort on the part of zoning or council to create a burden and deny you use of property. There were other issues that came up that probably were more instrumental in the creation of those laws. So I don't see that there is a substantial burden, and I disagree with the way it was applied. I think it should have been submitted as a brand-new SUP specific to that piece of property, rather than an amendment to a former SUP that was granted, because I don't think that's appropriate. But, like you said, under the new law, you're not allowed to even apply. I don't think it's up to this commission to decide whether or not that law is illegal or not.
Well, the special use permit was amended in 2013, so there is precedent there.
Yes, but
And there's-
that's before, that's 5 years before 2000, or 4 years before 2017, when the new ordinance was enacted.
Well, the ordinance deals with the use in the
Correct.
district. It doesn't deal with the special use permit process. The
Not
special
the
use
process.
there's according to your own code, there's a list of things that are can be utilized to deny a special use permit or deny an amendment to the special use permit, and I've listed those on the last slide. In my estimation, none of those are applicable to this situation.
Well, we have a code that says it is, and it's up to the zoning board to make the decision and then pass it to council.
Yeah, this is a good point. Bianca's reminded me of a good point. The code that you're mentioning, ma'am, 50-497, was amended. It already existed prior to that, so it wasn't a new ordinance. It was an ordinance that was amended. It existed in 2011. It existed in 2013.
Yes, yes, I was there when it was amended.
Okay.
Commissioner Baker, any more questions for
Not
for
right
them?
now.
Okay. Any other commissioners? No? Has any landscaping changes been done to this property?
Not to my
You
knowledge.
said nothing was done. Has any landscaping changes been done to this property? Yes, they've done some trimming. How about, did they trim all the way to the ground and pull stuff out so that it's flat? Or they cut some trees down and? But they took it all the way down to the ground, everything?
So if Wayside had a permit to do that work, John?
For trees, for weeds, but all the way down to the ground, is that, if we had to go over there now to just kind of take a peek at it, the changes you made were on the landscaping all the way down to the ground? Okay. All right. Okay. Commissioners, any other questions at this point? Anybody?
One question.
Yes.
So if the church Wayside buys all of the lots on Ivywood,
There's
What
one
is-
left.
pardon me?
There's one left.
One left. What does the church plan to do with the street, Ivywood? Are you going to purchase the street, leave it as a,
I don't know the
Pro-
answer to that. I don't know
a
if the
burden
church
on the
is.
city?
I mean, I would think there would be reason for the church to own the street as well. I would think that would be their desire, but I can't speak to them because I don't know if the church has made that decision. Just logically, I would think that's where the path they would go down.
thank you.
Okay.
Any other questions?
Attorney Fairmont, I think that's about it. I appreciate it, sir. There are some additional citizens to be heard. Respectfully want to honor those at this zoning commission meeting. I've got Mr. Frank Paul.
Thank you. Frank Paul, 112 Shalimar. As you know, I was here at the last zoning meeting primarily for another subject. Then this matter came up. And I was curious and started looking at it. And I'm listening to what the attorney says. I'm listening to what Ms. Baker says. I'm listening to different things. But one thing that was not mentioned tonight by the attorney was, I believe, unless I missed it back there, that our city attorney also, at the last zoning meeting in September, was very adamant that we should move this, agree to pass this forward, because he thought that we did not have the right to deny them the use of that property. Now, let me state, most of you up there know me, I'm not an attorney, and I'm not a member of the church, so I'm speaking as a citizen of the city. I'm tired of getting into lawsuits, I'm tired of all the ridiculous stuff that goes along, and I just hope that when we make a decision, we understand what we're doing. I don't know why it's back here. The technicality of the address being the city, there was no reason for that to come back to zoning, in my humble opinion. So anyway, those are my thoughts. Thank you.
Thank you, Mr. Paul. Next is a Barbara Bear. Thank you, ma'am.
Thank you for taking the time to listen to me today. I also attend Wayside, and I can tell you that we pour into this community weekly. I could go into how many bags of food that we give to citizens. I could go into various other ministries that we do across the city. We also helped to launch the Castle Hills Fiesta. And I am also here as a resident at 111 Mimosa because I also am a very proud citizen of this community. So I hope that y'all make the best decision. Thank you.
Thank you, Ms. Bear. Next on the list is Richard and Becky Smith. Thank you, sir. Thank you, ma'am.
Yeah, we're at 206 Antler, and I'd like to, as residents here, also put a word in for the church for Wayside. We are members there, and we benefit from the facilities that they have, and they're not only ourselves, but we have two sons, and they benefit from those homes also. So I do hope the council will see fit to grant them the amendment. Also, we want to do.
We're actually long-term visitors to the church.
Yeah, not members, but we do attend.
But we are here because we thought there was going to be discussion of Airbnbs. So if that's coming, we'll go back and sit down and listen. So.
Thank you all. Next is Sean Timlin. No comment. Thank you, though, for, okay. Anyone else? If anyone else would like to speak, please, on this agenda item. The time is approximately 7:33, and we are closing the public hearing. The time is now approximately 7:34 p.m. Agenda item 4. Discussion and possible action on a recommendation to City Council on an application from the Wayside Chapel Evangelical Free Church for an amendment to a special use permit, SUP, granted on March 2011 to add property located at 113 Ivywood Circle, legal description CB 5007B, Block 3, Lot 3, to the property included under the SUP. I'd like to mention that, Commissioners, this will be your time for open discussion. Just wanted to give a overview or review. We've heard Mr. John Gordon in the past. We heard a lot of this information. We've received multiple packets of information. We have approximately 500 pages on a USB. In regards to Wayside Chapel, we have the final opinion of Judge Royal Ferguson of the United States District Court, Western District of Texas, San Antonio Division. And that's something that after commissioners speak, again, I'm trying to respectfully describe for the public and anyone watching this to know the wealth and volume of information that we've had to research. Attorney Ferriman and Attorney Zuniga, thank you very much for the hard copy as well as the presentation piece. In the past, in reference to the handout from the attorneys, we received multiple documents in regards to 1069 ordinance as well as ordinance 1111 over multiple years involving schematics, diagrams, photographs. And I wanted to make sure to mention that, Ms. Baker, I'm not sure, well, who asked the question in the past when information was given to us by Mr. John Gordon, but I think you described what, in their big scope or big plan, what would happen after they purchased the 11th property, or the final piece of property of what their plans were. So I know that Attorney Ferriman kind of referenced that, but I'm not sure if you remember, but in the past minutes, past information, Mr. John Gordon described the details to us of what was going to happen after that fact. I know Mr. Schnall was referenced. I know Mr. Schnall has also mentioned integrity of the neighborhood. The city of Castle Hills and integrity of the neighborhood. Again, I just wanted to give an overview. If I've missed anything, please feel free to mention it. And as individual commission members, any comments you have, again, I'd like to mention that this is your time for open discussion on this particular agenda item.
John Herndon, I did have a question. What year was this property purchased? The subject property?
February 14th of this year.
Okay. I had one more question. What has been the use of the other properties that received the SUP previously?
Two of them are used to house visiting missionaries. The others are used for religious gatherings, Sunday school classes, meetings, instructional time, fellowship time. I'm sorry? Within the church, yes.
Anyone else have any comments at this point or would like to share? If not, what I would like to do is ask of you, I did reference not only the USB of approximately 500 documents. We expect a lot of our residents. There are a variety of ordinances. The handout that was given to us is an example of just a couple of the ordinances, but there are so many more. We also have the Texas Local Government Code. There's many things that we look at, and the document that you have, I think, is approximately 57 pages. Judge Royal Ferguson's final opinion. At the beginning of that, if you'd allow me, commissioners, to go ahead and just read a couple of excerpts, and defendant, I mean, this basically is Castle Hills First Baptist Church versus the city of Castle Hills. The defendant was the city of Castle Hills, and I'm reading off of page 1, which you all have. A general law city organized and existent under the laws of the state of Texas, a municipal corporation, and a local government entity. It is a small, landlocked community located within the city limits of San Antonio, Bexar County, Texas. Plaintiff, Castle Hills First Baptist Church, alleged causes of actions. And they mention RLUIPA, the Religious Land Use and Institutionalized Persons Act. I guess in the last 3 pages of highlighted, the last 3 pages of the document, disposition, there's a number 1, there's a number 2. Plaintiff's motion is denied as to the claim grounded in the city's denial of the additional, in this case, parking lot SUP because plaintiff failed to show a substantial burden. Further down, defendant's motion is granted as to the church's claims arising under 42 USC, and I won't read that all exactly, but you will also similarly see that in the handout given to us by attorneys Ferriman and Zuniga. For violation of the free exercise clause of the First Amendment with respect to the denial of the additional parking lot SUP. I'd like to mention that at times that this particular zoning commission, not this zoning commission, but multiple zoning commissions have voted for and have voted against in zoning matters. And I know that Wayside Chapel has been here before, and if you look at the history, there has absolutely been times that there has been recommendations to the city council governing body by the zoning commission for as well as against. The same page under disposition, number 3, in all of the respects, defendant's motion is dismissed without prejudice, subject to refiling consistent with this opinion on or before April 22nd, 2004. So anyway, as we go through this, the next page, as we go down that paragraph, RLUIPA does not require state or local governments to legislate on behalf of the federal government or require state officials to administer any federal program. And then as we step down a bit, number 8, conclusion, you will notice towards the end there, cities must govern the health, safety, and welfare of their communities, but in doing so, should consider carefully the positive and supportive role that a place of worship will play in doing so. I'm aware that at the council meeting, when this came back, Mr. Gregory being concerned about the health, safety, and welfare. But I do mention the other items about RLUIPA does not require state or local governments to legislate on behalf of the federal government. You have the entire document. I know that you've reviewed that document as well as the other documents, and attorneys Ferriman and Zuniga, we thank you very much. I know that your presentation as well as the handouts, and commissioners, Commissioner Baker, I thank you for your questions in regards to substantial burden and other things. And Mr. John Gordon, thank you very much for I know you've been to multiple meetings, but sharing with us historically some of those pieces. We will accept a motion if someone would like to bring one forward.
Well, before bringing on a motion, I'd like to just say, I'd like to bring my opinion on some of this. And I've looked at some of this extensively. I think there's an argument for substantial burden, but I'm not sure. I'm not 100% sure there is one here, but I believe that they're perfectly within their rights to bring this, especially in light of the fact that there's discrepancies in the city code from the time that they originally purchased to now. I know that there's probably at some point going to need to be made clarity in the new code unless they, the problem I think is we've set a precedent by allowing that other SUP. And I think by changing the code, I don't think that nullifies the precedent that was set last time. I do see how they can be an impact on the neighborhood for the immediate residents, making it a little bit rougher, but I also see how they can, it maybe in the long term, work with the city in trying to bring forward solutions to some of the problems that have been had over there. I don't know what type of work has been done in the past with the church. I'm new on the board, and I think there is a solution there. I don't know that we could, personally, I don't think I can give a fair argument since there has been a precedent set with this particular church. I feel that they bring a pretty good argument at this point. That's just my opinions on this matter.
We thank you, Commissioner Herndon. Anyone else? I know I started here, but courteously, I wanted to honor Commissioner Herndon's request there. We will accept the motion if someone would like to bring one forward. This will be a recommendation to the governing board, the city council, as the zoning commission recommends to the city council.
I understand why our attorney, Mr. Schnall, has suggested that this zoning board should approve this application. And I disagree with the aspect of the precedent, because we did pass or amend a new ordinance in 2017, and it gives the city and the zoning board the authority to deny applications in Zone A residential. You can do it in everywhere else, just not Zone A residential if you're a church and the other entities that they listed. And I do have concerns that it appears inconsistent. I'm still opposed to the whole way it was brought. It's like a subterfuge, in my opinion, to attach it to a formally approved zoning ordinance or ordinance that allows you an SUP. But I believe Mr. Schnall pointed out that the last board that passed this application approved it, and it was sent back. And so we're hearing it for probably the third time. So to bring y'all up to speed, that's kind of where we are.
Thank you for the commentary. Again, we will accept a motion if someone would like to bring one forward. Commissioners?
I'd like to bring forward a motion on passing this as requested.
We have a first by Commissioner Herndon. Do we have a second? Do we have a second? Motion fails for lack of a second. Once more, we will accept the motion if someone would like to bring one forward.
I move that we deny the application with the full understanding that City Council will take our recommendation as merely that, a recommendation.
We have a first by Commissioner Baker. Do we have a second?
I'll second.
Okay, I had a hand up here quickly. Second by Commissioner Pena. All in favor? All opposed? Any opposed? Passes 4-1. If I could, Mr. City Manager, to make, ask or have a request when this goes to council of a footnote could be added for the work this zoning commission has done, is that they've had approximately 500 pages on a USB of reference material in regards to this item, in addition to the final opinion of Judge Royal Ferguson, the U.S. District Court, Western District of Texas, San Antonio Division. The time is approximately 7:53 p.m. completed agenda item 4. If we could go to agenda item 5, and it is approximately still 7:53 PM. I'd like to open the public hearing on a proposed amendments from the Zoning Review Committee regarding revisions to Chapter 50 of the Code of Ordinances. The discussion will include home occupations and I'd like to rescind that reading and like to go back, please, for the record. The time is 7:54 PM. Agenda item number 5, public hearing on proposed amendments from the Zoning Review Committee regarding revisions to Chapter 50 of the Code of Ordinances. The discussion will include short-term rentals. City Manager, is anyone signed up by chance to speak about?
I gave, the list there doesn't specifically say, but I know Mr. and Mrs. Smith wanted to speak on it, and
Okay,
so we have at least 2 people here that would like to speak.
okay, thank you. If we could request for you to come up, Richard and Becky Smith, please, we would appreciate the opportunity to hear you. We have actually a listing, and I can ask the city manager to highlight some of those bulleted for us. You can't, okay. Thank you, Ms. Tillman. Trying to be as respectful as possible of your. Okay, Richard and Becky Smith,
All right, 206 Antler.
206 Antler. Okay, thank you.
Would you like to?
Mr. and Mrs. Smith, can y'all speak into the microphone?
Sure.
Yes,
We
okay.
couldn't hear you last time,
We're not used to that.
or I couldn't.
Okay, we are completing a complete remodel and redo of the home on 206 Antler Drive that I inherited from my parents. And we hope to make it I call it a vacation home, but I think the term is Airbnb now, more and more. We had owned another home off of McCullough, and we had that same type of business for 9 years, I believe. And it was a wonderful way to use a property that you love very much, that you have remodeled and fixed up and made very beautiful, and that you don't want the property to deteriorate or be abused by people, but you still have a need for income. So I am so very glad that this new type of rental came on the scene some number of years ago. So we had to sell that property, and we hope to do that again. And I just want to say this as perspective. The neighborhood over there by McCullough, I saw deteriorate over the years, as neighborhoods do when people get older and they can't keep up their yards or they pass, and sometimes those properties become rent properties. And we unfortunately had our street over there, Stockton Drive, increasingly taken over by rent properties, often to college students, and it was very sad to see the neighborhood, in my opinion, go downhill with that kind of thing happening. Our home had 2 rent properties, one on the left and the right, with college students, and yet we were able to operate the vacation home until the college students just got to be too much. But our home had perfect landscaping, literally manicured, not a weed anywhere, because the pictures are what sell the house, and those pictures are online for everybody to see. So now I see my street, Antler Drive, and I believe there are some rent properties there, and my parents had rent properties. I understand that when you're owner of a home like that, you aren't going to plant flowers and things because the tenants probably won't keep it up. And you as a tenant aren't going to take your time and money to beautify a home that you don't own. So hence, those homes often are not attractive and sometimes even worse than that. So we have put in an astonishing amount of money into this house, and I believe it'll be the most beautiful house on Antler Drive. Everybody can go and vote on that. But I just hope that as the arm of government begins to regulate this, and the San Antonio didn't regulate our home for a number of years until they started to, that the requirements be kept minimal, because those things are what either encourage or discourage people from choosing certain avenues of action. And you always want, if you're going to have a street with several homes that are rented, you definitely want them to be vacation homes because they'll be the prettiest houses on the block. And my neighbors on Stockton Drive, where our other house was, could tell you we were careful to screen people. It was always very quiet, and people never caused any disturbance to the neighbors around us. We kept a tight control of who was coming and why. No parties, no noise was allowed. So my neighbors were devastated when we told them we were going to sell the property because they said, you've been great neighbors even with the rental. So I just want to encourage a minimum of regulations and hoops to go through, because it's a lot of work to maintain a home like that and go frequently to clean it and watering always so everything looks perfect. And I think this home is going to encourage my neighbors to maybe spruce up their yards just to kind of keep up with us, because ours is going to look fantastic. So that's my comments.
Thank you, Mr. Smith. Appreciate it. Ms. Timlin?
Sean Timlin, 400 Foxhall. I just want to reiterate what they said about keeping the requirements to a minimum. I know there's many for rent properties already on Airbnb in our neighborhoods, and the more regulation you put, the more people are just not going to do it. The more cost to go through the city, the more people are just going to ignore the whole thing. So I think if you do enact what's on here, it all looks pretty legit and not too expensive and not too many hoops. But I just want to caution you not to make it too difficult, because there'll be people, many people, that will just go around it.
Thank you, Ms. Timlin. Ryan, thank you very much for putting together the documents for us. The short-term rental permit application that we have, and then the draft ordinance, Ryan and Mr. Schnall, thank you very much for that. I'm not sure if you wanted to discuss that or present a couple of items to us in regards to these.
I think the first thing you need to do is ask if there's anyone who wishes to speak at the public hearing, and if not, close the public hearing and move to the next agenda item.
Okay. Would anyone else like to comment on this agenda item? Anyone? The time is approximately 8:02 p.m., and this public hearing is closed. Thank you. Item number 6, it's approximately 8:03 p.m. Discussion and possible action on a recommendation to the City Council on amendments to Chapter 50 of the Code of Ordinances based on recommendations from the Zoning Review Committee. Commissioners, this is your time for open discussion. And I will be asking again if the city manager and Mr. Schnall would like to give an overview, but if you have some questions beforehand, we absolutely would allow those right now, ongoing throughout this agenda item. Anyone, commissioners?
I'd like to thank everybody that made comments, because some of those things we hadn't really heard before, but they do make sense, and I appreciate that. Hopefully, after you've read the proposed ordinance, you can make additional comments, and I think part of the plan is that we gather as much information and then present it for a public hearing. So you have another opportunity to come and maybe have reviewed it with other things. We don't know everything, and we have absolutely depended on our city manager, who's done a fantastic job in providing multiple different cities' scenarios on how they deal with this. And we didn't want to make it too awful, but we didn't want to make it so easy that, you know, they were popping up everywhere. That's rather disturbing, I think, to a number of the citizens. And one of our city council people had suggested that, well, basically that's just allowing a hotel to be operated in a residence. And that could be true, but I do think short-term rentals are something that we need to do.
To add to that, I think last zoning commission meeting, there was some discussion on timelines. And Ms. Baker talked about the holidays coming, and I, first of all, I want to say I appreciate that, because, yeah, we do find a downtick in attendance in meetings sometimes, at all the meetings that we have when the holidays come up. But from a standpoint of timelines, I think that we discussed a multitude of details. Details were presented, and I'm speaking specifically regarding this agenda item of short-term rentals. And I know that I think Mr. Reply had put in the newspaper or the posting for this already for.
Yeah, well, I'd published and put the notice in just in case there was any action taken at this time based on anything within Chapter 50, the home occupation, and short-term rentals right now, and moving it forward to council. But if you opted not to take action, needed a little more time before the next zoning meeting, and which moves it into the November council meeting, again, just we would publish again for notification purposes.
Yeah, and I'd like to share with this commission, being mindful and aware of Commissioner Baker's last time to move things forward. If you all, as a commission, decide on this agenda item that you'd like to move things forward at a quicker pace, I am aware that the public hearing not only can be handled here, but that public hearing can also be handled by the governing body of the city council. So in either venue. But again, I'm trying to be respectful from a standpoint of, wow, when we had that public hearing, time is of the essence when November and December come along.
Well,
Commissioner Baker?
That raises a question. Would we likely have a better attendance if it was the city council that held a special meeting on short-term rentals?
I'm not sure, again, it's the way it's packaged. I mean, if you had a meeting just specifically on short-term rentals, it's just a matter of how we would promote to have people attend, to speak, and provide any other input to capture before actually going to council.
Right.
From that standpoint.
Okay, and I think that everything under this agenda item could be packaged, and we could move it forward on a timeline so that it could get to council. So under the, I guess, the publishing, et cetera, that our city manager has done. So unless I'm wrong, it could all be packaged together.
That's the option of the commission, but if the commission is inclined for there to be a special meeting of the city council to be focused on short-term rentals, that happens when this commission makes a recommendation for language to be added to Chapter 50, the zoning ordinance, in regard to short-term rentals. The council is looking for a recommendation from the zoning commission, just as our ordinances provide that the zoning commission looks for recommendations from a zoning review committee. So you have gone through, you and the predecessor commission have gone through all of the recommendations from the zoning review committee and have taken action on all of those recommendations except short-term rentals. So, and you heard the folks who came tonight to speak during during the public hearing on this matter spoke specifically on short-term rentals. So it seems that y'all might consider, no matter what you decide to do about having a subsequent public hearing on the whole ordinance again, you ought to at least continue this discussion in regard to short-term rentals so that the chair and the commissioners as a whole can see if there is a consensus about the kind of ordinance you want to recommend on short-term rentals, if any. And that is one way to move this forward, because all the other recommendations from the Zoning Review Committee have been addressed, and Mr. Rapley has what I'll call a red line that shows the changes that this commission and the prior commission, and maybe I should say prior commissions, have incorporated into a recommendation to the City Council. The only thing that is missing is the adding of language on short-term rentals. And I believe Mr. Rapley has presented an updated proposed ordinance. It could either be a standalone ordinance or it could be incorporated in, as Mr. Rodriguez said, it could be folded into the overall ordinance. It is just a situation where the commission needs to take some action on this to have it get to the City Council. And so one question for the council, for the commission to consider is, do you want to simply focus on short-term rentals and take action perhaps tonight, if not tonight, at your next meeting on a recommendation on short-term rentals? Or do you want to take that action on short-term rentals but fold it into the overall recommendation? There have been a lot of meetings and a lot of public hearings on these recommendations. I can't remember exactly when the recommendations of the Zoning Review Committee were originally presented to the former city manager, but it was no later than the summer of 2016. That's 3 years. It's almost ready for the council to appoint a new zoning review committee. So it seems to me that it would be appropriate to continue to move this forward. Last month at your meeting at the beginning of September, you approved the home occupations language. That leaves short-term rentals. There were several recommendations made at last month's meeting about the permit prices and renewal prices and things of that nature. There was also a comment made about taking out the term mobile homes, defining hostels and excluding hostels from being permitted. And there was some recommendation to incorporate into this ordinance the state rules on swimming pools. Mr. Rapley and I discussed this matter this afternoon. I don't know if you have the updated version, but what we discussed was going ahead and making sure those fees were in there the way that the commission recommended them at the September meeting, taking out mobile homes, either taking out hostels entirely or defining it and taking it out of where a short-term rental property, that a short-term rental property could not be a hostel. And we discussed the state law on swimming pools. And the difficulty that both Mr. Rapley and I had, and obviously I will let him speak for himself, was that the state rules on swimming pools are written exclusively for and apply exclusively to a pool owned, controlled, or maintained by the owner of a multi-unit rental complex or by a properties association, properties where the doors and windows of rental dwellings open into the pool yard of a multi-unit rental complex, condominium, cooperative, or townhome project. So the state rules do not apply to a single-family residence. My suspicion, or my supposition, is that the reason they don't apply to single-family residence property is because they are so onerous that it's my view, at least, that if you adopt the state rules and apply them in the short-term rental ordinance, you may be essentially precluding a property owner's home being used as a short-term rental if it has a swimming pool, because the pool yard requires a 4-foot high fence. It has to have a certain kind of gate with a certain kind of gate enclosure. If a door or window on the residence opens up into the pool yard, there has to be some kind of alarm if the property was built after 1994. The rules are good rules. They're especially good rules for multifamily dwellings like apartments or condominiums, but they're not very friendly to single-family residences. And so my suggestion to Mr. Rapley this afternoon was that we bring this information to the commission and seek guidance from the commission in regard to whether there were specific safety rules that relate to swimming pools that you would like to see in the short-term rental ordinance. If there are not, it may be ready for action as it stands now, depending on the views of the commission. If there is, and I believe it was Commissioner Herman who made a comment last month about the fence needing to be the pool yard enclosure or fence needing to be 4.5 feet in height. The state statute requires a 4-foot height. If there are things like that would not be create a terrific financial issue for a single-family property owner who wants to use it as a short-term rental, but as a swimming pool, we certainly would be receptive to and want to try and get those in there if that was the wish of the commission. But incorporating all of the requirements in Chapter 757 of the Health and Safety Code on pool yard enclosures may be a little bit more onerous and a little bit more expensive than would be indicated, and would not meet the spirit of the two ladies who spoke during the public hearing, who talked about minimal as opposed to maximal kinds of regulations. I certainly want to encourage safety, but at the same time, there's kind of a balance here.
Thank you, Mr. Schnall. Commissioners, any comments? Somebody?
Chairman, I'd like to add, and
Yes.
and again, in speaking with Mr. Schnall today and doing research on other cities who have short-term rentals, it was very difficult to find anything regarding regulations in pools. I did find some where folks who were renting out the property had to sign waivers for liability reasons. I reached out to San Antonio to the person who was the spearhead of the short-term rental, and she said that they didn't include anything regarding pool safety or guidelines in that matter. So I just want to let you know, it couldn't find anything really applicable to that under anything regarding short-term rentals for other cities with ordinances. So just want to make that a point.
Thank you. And thank you for the documents. I think we've got, I guess from a standpoint of, from a documents perspective, some good infrastructure here, because we do have to start somewhere. The city needs to start somewhere, and we need to be cognizant, commissioners, of the timelines to be able to move things forward and get the wheels in motion running. Commissioner Herndon?
Yeah, I had a question, and this is kind of part question, part comment. I put a swimming pool into my residence a few years back, and if I recall, we had to meet all state guidelines when we installed it as to fence, security, alarm on the back doors. I believe it was everything you mentioned except maybe the windows being alarmed. Is that I was meeting the city code, or was I meeting a state code requirement?
I'm pretty sure that was the state code. I was looking for a copy of our city ordinance, which I did take a look at this afternoon as well, and it was minimal. The city code on swimming pools was minimal. I'm not sure I have a copy of it right in front of me, however. I'm somewhat surprised that your pool provider, had all of that stuff done. I think it's a good measure of safety.
Well, wait, I wanted to say, wasn't the pool provider, it was the City of Castle Hills inspector that required it.
Okay. Well, I need to see if the city has incorporated that requirement in the swimming pool ordinance.
It may have been under international.
Or it may be part of the International Building Code.
For pool and spas.
I think that may have.
Okay.
Yep.
Then that's why. Okay.
Louis?
So that would only affect newly built pools?
That's correct? Huh?
Okay. Okay, so that's why. In that light, if that's the city's requirement already, although I am still concerned about the potential extra expense and regulation, if it's already what the city requires, then we can incorporate the rules in Chapter 757, or perhaps the rules in the applicable International Building Code. There is an International Pool and Spa Safety Code. If that's what the city has adopted, it makes a little bit more sense to me, since that's what our building official is referring to, that if we were going to incorporate any code requirements, it would be what our building official would look to, which would be the International Swimming Pool and Spa Code. And if that's the will of the commission, we can certainly do that. If there are other things that the commission wants beyond that added to this ordinance, this would be a good time to kind of let the staff know, so that we could get those incorporated in and bring this back to you at your next meeting. Or if there are none, and what you want us to do is incorporate into this ordinance the reference to the applicability to this ordinance, incorporating by reference the International Swimming Pool and Spa Code that the city has already adopted. That could be done by motion this evening as part of, instructing us to add that and complete this draft ordinance. Whatever is done on this tonight, I would suggest that you also have a brief discussion on whether you want to come back as a commission, give notice of another public hearing, and see if you get any additional questions or comments from the public, and have an opportunity as a commission to tweak or fine-tune, whether it's short-term rentals or anything else, before it goes to the city council. And holidays notwithstanding, when the previous zoning review committee's recommendations went to the city zoning commission and then to the city council, there were at least 2 and perhaps 3 meetings of the city council where the council considered portions of the recommendations rather than everything all at once. And I recall that because at the time, I was the chairman of the zoning commission and had the responsibility to make the presentation to the city council on the recommendations that came from the zoning commission. And my thinking would be that to do this in what I'll call bite-sized pieces, that when you do make a final recommendation, that the city manager look at having it presented over the course of 2 or 3 council meetings, specifying which provisions, which sections of the code would be considered at each meeting. And the council would hold a public hearing, and then the council would have an opportunity under a separate agenda item to discuss and take possible action on those portions of the ordinance.
Okay.
And do it kind of piecemeal, but that would allow it to be done in a fairly orderly fashion. But as I said earlier, it starts here.
Right, exactly.
So it starts with, I think that, you put on the agenda for the public hearing, you're going to talk specifically about short-term rentals. That's the open issue. I would encourage you all to talk about the short-term rental ordinance and see how that comes out this evening, and then see whether you wanted to have another meeting of the commission or simply direct the city manager to take the package to the city council in maybe 2 or 3 pieces.
Okay. Yeah, because the council has the authority to break it up into chunks as they see fit, as the governing body. But from what I heard here in Commissioner Herndon's comments, and from Mr. Schnall here also in regards to the pool pieces, it sounds like appropriate actions and processes have already been taking place. Those wheels have been in motion following state law and other things, as well as the International Building Code, et cetera. But those wheels are already in motion. They've already been enacted and taking place already. Does anybody have any comments on the documents themselves that we reviewed, the latest? I guess I just wanted to verify beforehand on that, is that I thought I remembered that a statement was made that there's flexibility in this document if fees needed to be changed, that they would not be so rigid, that was built into the document the way it's written?
Well, I currently put in the application as what was recommended, I think, not last meeting, but the previous meeting, I think, which was
Right.
$250, and then the annual inspection of $125.
Right. But I mean, as it's the governing body by city council,
Yes,
once they decide on everything else, that it doesn't have to be coming back every time there's a change, that understanding state laws, understanding a variety of other circumstances, that there's enough flexibility that these documents have legs and they can stand on their own in order for the city to enact upon them.
Yeah, and the fee schedule is amended or added by council in the first place.
Okay, I'm sorry, Commissioner Pena.
Question, what type of lease agreement do y'all provide the short-term renters? Is there a standard agreement that y'all utilize from the San Antonio Real Estate Association, or?
Hang on one second there. I think we need to address Mr. Schnall, if you could, or the city manager. Just, I'm not sure if we can really engage.
This is really not part of the public hearing.
I apologize.
You can, ask Mr. or Mrs. Smith to comment if you wish, but my answer is the city is not, it is not appropriate for the city to provide a form of lease or anything else. All that does is give the city liability.
I was not implying that, sir. I was just asking a question.
Okay, I'm sorry,
Okay.
Commissioner Pena.
I'm not aware of any standard short-term rental lease that is used by a private owner renting to a private short-term renter. I think that Airbnb and the vacation rentals, whatever that acronym is, I think they do have a standard lease type of form or type of agreement that the property owners use and the short-term renters use, probably done through electronic signature on the internet. You're certainly welcome to ask Mr. and Mrs. Smith if they use a form of lease.
Commissioners, did you?
Okay, and there was one more question I wanted to ask, and I guess I should ask
No,
Mr.
Commissioner
Schnall.
Payne.
Is it possible to request that the owners of the Airbnb provide the tenant with the tenant notification sheet that has a sketch of the designated parking areas, and that your short-term renters keep a copy of that in the house, so that if they break the rules and the police are called out, they will have a copy of what's allowed, where they're allowed to park, and how many people are allowed to be in the house, or, to stay in the house?
There is a draft tenant notification sheet. I don't know if Mr. Rapley has
I know,
passed it out.
It's a sketch.
There's a draft short-term rental permit application, which is the first page. The second page is a continuation with some information, and the third page is a tenant notification sheet. Big bold-face print, please read and be familiar with this information. First item is maximum occupancy is, and the owner would fill that out. The second is parking is permitted in designated locations. No parking allowed in landscaped areas. Failure to comply with parking restrictions may result in a citation. There's something about noise. There's the emergency contact information, statement about maintain free of litter and debris, and the emergency number 911, and the police department phone number as well. What I don't know is whether there's a requirement that there be a drawing or a sketch illustrating or showing exactly where the parking is, and that certainly would be a reasonable requirement. It might also be reasonable for that notification sheet to point out that the city has an ordinance that prohibits parking on the street
Yes, sir.
between certain hours.
Yes, sir.
Commissioner Pena, any other questions?
No, I just wanted to make sure, I didn't know if the owners of the house would be mailing it to the people and they wouldn't have it in the house available, or if they sign it and keep it in the house while they're renting, while they're occupying the house. Okay.
Are you going to recognize them?
Yes.
I'd also like-
Commissioners, are we able to recognize the audience member who spoke earlier? Commissioners? Commissioners? Oh, yes? Yes. Mr. Herndon? Commissioner Herndon? Is that okay with you? Is that okay with you? Okay, thank you. Yes, please.
Don't know all the rules. When we started renting the house that we rented for 9 years, that was '07, we found a book on how to make your vacation property work for you was the title, and it gave us some suggestions, and it was apparently written for people that have like condos at the beach or a mountain cabin, but so it was kind of a new thing to just apply it to a residence. But we just created our own documents with information we needed from the people, and then we had on the front door a little sort of card laminated like often hotel room doors have in case they couldn't find our phone number or whatever. Our home just had a 2-car driveway, and they knew that's where you had to park, right on the driveway, and some check-in and check-out information, kind of just copying what we had seen in a regular hotel room would have. But we created all of our own documents at that time. There wasn't really, I'm sure things are available now that, yeah, that was back in the past. But yes, we were able to do that and mail those things to them, but also post it in the residence, right, where they could find it.
Okay.
Absolutely. So.
Okay.
Thank you.
Thank you for answering my question.
Yes, Mr. Rapley.
Chairman, to answer Ms. Pena's question, and I'm not sure, maybe this page had dropped off that was on the original draft, and then I added bullets as a result of last meeting, which had a submittal checklist, which is a request for the owner to bring in, when they go through the application, the meet and bounds description survey. I think there was a request by the zoning commission to supply the deeds. A list of all owners, operator, agents, short-term rental, including name, addresses, current email address, owner, operator, telephone numbers, a sketch or narrative describing the location of available parking spaces, a sketch of the floor plan which identifies sleeping areas, proposed maximum number of guests, evacuation route, and the location of the fire extinguishers. That's all on the checklist that they would be
Checklist.
required.
Okay, it was not in my packet.
What's that? I know the copies I laid out, it may
Yeah.
not have been the third
Yeah,
page, so.
Yeah.
It should be on the back of that if it was double-sided, sorry.
Okay. Commissioners, over the course of several meetings, we've received a lot of information. You've made a variety of changes. I know that Mr. Schnall had mentioned even as far back as 2016, some of the items, which is like, wow. But in addition to that, I think that we have covered a lot of information, and it is strictly my comment, you as commissioners of the zoning commission, again, my attempts to move things forward from a standpoint of all the work that has been done, it would be my opinion, and I'm probably going to be calling to accept a motion, but my comment would also be to go ahead and package all of this together as one of the statements of many statements made by the city manager and Mark Schnall as an example. One of the options, I guess you could say, that we had to package everything together, because I would like to get this to the city council sooner than later, understanding timelines, which was brought up last meeting. So aside from that, I mean, those were my comments, and I want to thank everybody for great questions on all of the details that we've gone through, and I know that this is just a small portion, and city manager, you've compiled a variety of things for us, and a variety of research, and Mr. Schnall. Commissioners, any other comments? I know I made a couple there, but.
Chairman, if that was the wish, I would say that we could probably package it all together and bring it forward to the meeting, your next meeting for zoning, and have one final look at all aspects of this.
Okay. What my comments were, Ryan, was to actually package it up tonight for council at their next meeting.
You mean next Tuesday night?
Correct.
For October 8th?
So package it up tonight for them. That is my comment. So I'm not sure, Commissioner Baker?
Well, I have a question. Is it appropriate to pass a motion that incorporates everything we have with the addition of language on the International Building Code with respect to pools and spas? Or do you need to have that language firmly
I would
within
have
the code?
I would have to get with our building inspector and find out the specific language that we would add to that ordinance.
We can't just refer to it?
Well, we don't know what we're referring to, that's the problem.
Okay.
One of the cities I represented within the last 90 days adopted the 2018 International Swimming Pool and Spa Code. I don't know what year code the city of Castle Hills has adopted, and it may not be the swimming pool code. This may be part of the building code, so we would need to confirm that with the building official.
When Mr. Schnall, as an example, our compliance officer, were to go out, I'd like to ask while he is here, is there a particular point that he references? Yes, sir, please. Thank you so much in advance.
Yes, sir. Louis Amarco, Compliance Officer, Interim Administrative Assistant to the City Manager. To answer your question directly, I personally concern myself with a particular section of the International Property Maintenance Code having to deal with the maintenance of the swimming pool. The building inspector does refer to the same section of that code in that particular subsection when it discusses gates. There is some gate nomenclature in a particular section. I have it written down in my notes precisely, the section, but as far as window alarms and door alarms and things of that nature, that would be something that the building code, the building inspector would be dealing with. And since I did not see it in the IPMC, it's most likely in the International Building Code section, chapter.
Yes, Commissioner Herndon?
In the maintenance code that you are using, is it for the pool and spa safety? Do you happen to know that offhand, what the requirements are? Are they something you can do out of your head when you go up to a property, or do you have to have a book with you when you go through it?
Primarily, I deal myself with just simply maintenance of the pool, in other words, stagnant water. Pools are to be maintained in a safe, they're to be maintained and also in a safe manner. That's what the code says as far as...
Is there anything addressing the gates around the perimeter of the property?
Yes, sir. It does address that. In this particular section of the property maintenance code, it does address a 48-inch gate with an outside latch.
An outside latch, that, yeah. Thank you.
Thank you so much for your comments and helping us here.
Yes, sir.
Commissioner Baker, and again, just from a standpoint of referencing that when they look at it, for them to take action, if that is the sole item, strictly my comment, like I said, we'll think about a motion here in a little bit, but my comment, I'm not sure what the other commissioners would have to mention to you, but mine would be to mark that as a reference point for the council to consider, because actions are already being taken, as our compliance officer had already mentioned. But Commissioner Herndon?
Yeah, I mean, I think there's a big difference between the new building code and the maintenance code.
Okay.
And I believe you're going to find something from one end of the spectrum all the way to the other as you go through houses in Castle Hills, being that there's been pools built for many, many years here.
Okay.
And the fact that he can monitor and maintain under the building maintenance code, I think maybe that should be the one. It's less burdensome, but I think that might be the one we need to address.
Okay. And I know that things are constantly changing, and as an example, I think our Texas Local Government Code book may be updated here in November as an example. So things are constantly being updated, so that's why I made the comments that I made earlier. Commissioner Booth, anything at all, or?
Under section 50-104, page 2, item 7, it refers to the contact person being notified within 60 minutes. What if they're not responding within the 60 minutes? What happens? Is there a penalty, or they have an alternate person, or? Yes, second page, item 7, fourth line from the bottom of item 7.
B.
It says the local contact person shall respond within 60 minutes of being notified of concerns, requests for assistance regarding the condition, operation, or conduct of guest of the short-term rental, and shall immediately remedial action as needed, resolve such concerns or requests for assistance. So what if that doesn't happen?
If that doesn't happen and the city is informed, the city building inspector or whoever the appropriate official is could issue a citation to the local contact person. But I'm going to defer to Mr. Rapley for the source of this provision.
But in reading item B, I would kind of be in agreement from a standpoint, it's a compliance item, but your question is what actions would be taken.
Right.
Is that correct? Okay. Mr. Rapley?
As far as that, this was obviously utilized under the other, one of the ordinance that I use under this. I don't have to look as far as what penalties were described under there, but this was the standard language about contacting in that notification time. I'd have to find out, again, exactly what the penalties might be for that in the particular cities that we pulled this from, so.
Well, the other sanction in here is in 50-104, excuse me, 50-108, where the permit to operate the short-term rental could be suspended or revoked if there were violations of the ordinance. You know, whether this provision is realistic is something that the commission can think about, because I think Mr. Booth's point is that being available 24/7 may not be realistic, and that even if you are available 24/7, it may not be realistic to respond within 60 minutes. There are plenty of times, like right now, where my phone is off, so that it doesn't disturb this meeting. You go to a concert, you can't hear it if it's real loud, and if it's real soft, you better have your phone quiet. So, you know, I'm not sure that's something that the city can realistically enforce, but it may be in here, and it may be in here from other cities, in order to encourage the owners of short-term rentals to recognize that they do have a responsibility. A comment was made about, you know, operating it, you know, having the signage up like is in a hotel. Well, if you're in a hotel, there's someone on the staff there 24 hours, 7 days a week. And the purpose of this may have been to impress upon the owner of a short-term rental property that they do have a responsibility for availability. But I don't see any other remedy that the city could enforce other than a citation, and then if there were a conviction of a violation, the potential implication of Section 50-108 on a potential suspension or revocation of the short-term rental permit. That may not be much of a remedy, but it's about all I can tell you that there looks like there is. We certainly can compare it to what similar ordinances in similar cities have. That's, again, something for you all to consider. It's notwithstanding what I said earlier about how long this has been pending, I'm not sure another month makes any much difference, Mr. Rodriguez. I think what is important is for this commission to be comfortable that you're making a recommendation that you feel is appropriate. And I wouldn't want you to rush it simply because it's been around for a while. You know, I'd like you all to, you know, think about the implications of this. And the section Mr. Booth pointed out may be a section that should be referred back to staff to see, you know, is there a way to provide a little bit more teeth in it, or is it just asking too much, and whether the city should even be involved in that? Because ultimately, the person who is paying for it is the one who expects the service and is the one who's really entitled to a remedy if there's a problem and it's not resolved. I'm confident that the VRBOs and the Airbnbs have in their contract provisions about customer satisfaction, and a successful operator is going to want to have that kind of a reputation because everything's available online instantly. And, you know, if I'm looking for one of these in another city and I look and see that the reviews of that property are really low, I'm going to look for another property. And I think most people would do the same thing.
Yes.
Nevertheless, I think Mr. Booth's question is a very fair question. If we put it in there, how are we going to use it? And if we're not going to use it, or if we can't find an effective way to use it, maybe we take it out.
I think that was a great question, Commissioner Booth, and but also I think it's also a piece when someone is looking at language, it does invoke encouragement.
Sure.
From a standpoint of paying attention to the details of documents that you are signing. So, but any other comments, commissioners? It's good documents here, but let me, we will accept a motion if someone would like to bring one forward.
I'd like to move that we ask the city staff to provide appropriate, either through the internet, I guess, research what we currently require and what the International Building Code, maybe with the help of our code compliance officer, to establish guidelines for short-term rentals that have pools.
I'll second that.
Now, again, we have an agenda item in place. We can go ahead under this agenda item, move on that. We have a first, we have a second. It is my understanding that we can still add additional items or additional motions, that this particular agenda item offers that flexibility. So we do have a motion on the floor. I'm sorry.
Mr. Chairman, can you open item number 11? Because I think Ms. Baker's motion is really a little bit more germane if it's under item number 7. Because it's really in addition to the recommended changes, in a sense.
Well, we could.
I'd be a little bit more comfortable because number 6 is limited to discussion and possible action on a recommendation of the City Council. And Ms. Baker's motion is really not on that subject. The alternative would be, rather than it being a motion, Ms. Baker, to simply have that be a suggestion, and if no one on the commission objects, then the city staff will follow that recommendation. Because I am concerned about the commission not doing something that is not directly permitted under the wording of the agenda.
I withdraw my motion, if that's appropriate.
Motion withdrawn.
Okay. But the suggestion stands.
We had,
Yes, sir.
suggestion.
Okay.
That
So we're
particular
asking
motion, we did have a first and we did have a second motion to withdraw. Okay, accepted by the commissioners.
So
Agreed?
For clarity's sake here,
Okay.
we are asking the city staff to come back with a recommendation for pool safety,
That's correct.
whether
I
it's
hope that's
through
what
the
y'all
IBC,
understood.
International Business Code or through the International Maintenance Code. We're asking that they come back with a proposal. Thank you.
Okay, so that's through both, okay. All right, we're still on agenda item 6, specifically, if I may read again, discussion and possible action on a recommendation to the City Council on amendments to Chapter 50 of the Code of Ordinances based on recommendations from from the Zoning Review Committee.
I think since we are asking for more information, it's appropriate to pass this to the next zoning meeting.
We will accept a motion if someone would like to bring one forward
No motion
regarding that.
Mr. Chairman, no motion is necessary on that item. I mean,
Okay.
they're just simply, I think Ms. Baker's suggestion is that no action be taken under item number 6.
That's what I was hoping to hear, so,
Yeah. Yeah,
or no action taken.
and no action taken, it allows you to move to item 7 unless there is something further a commissioner wants to discuss under item 6.
Commissioners, this is your time for, again, open discussion. Now's your time before, as was mentioned, I may be closing this item here. Anything else? The time is 8:53. Agenda item number 7, discussion on potential additions to the recommended changes to Chapter 50 of the Code of Ordinances.
So, Mr. Chairman, this is a point in the meeting where if a commissioner has noticed something in a prior portion of the ordinance and wishes it to be reconsidered, this would be an opportunity for the commissioner to do that. And if there is no one who has any potential additions or changes to the recommended changes, then this would also be a no-action item this evening. And the plan would be, I think, to get the short-term rental ordinance modified to reflect the incorporation of the appropriate codes, and also, I think, to incorporate Ms. Pena's comment about making sure that that where the designated parking is actually designated somewhere on something that both the city has and that the occupant of the short-term rental has, and bring that back for the commission for what would probably be the last final look and the last public hearing before you ship this to the city council.
Thank you, Mr. Schnall. Again, I just wanted to reiterate, to be helpful to the commissioners, to try to keep things in a uniform manner, and I gave strictly as samples in prior meetings to move to approve, not approve, take no action, table to when, a particular date. You could read the agenda item, and again, this is only a sample to avoid any stress or confusion in regards to this. So would anyone like to make a statement or make a motion in regards to agenda item number 7, and then also with considering the statements that Mr. Schnall had mentioned?
I suggest we take no action.
Do I have a second?
A second.
All in favor? Any opposed?
Chairman?
Yes.
I will send out a draft of this ordinance and a copy of that application, because that page was missing on the copy I made. So you can all have it moving forward between now and the next meeting.
Okay. And we did have that prior, the checklist prior in the other packet also,
Yes. and
prior packet.
I'll email it out so you have it between now and the next meeting.
All right, agenda item number 8, and the time is approximately 8:56 p.m. Would entertain a motion, please? Do I have a second? All in favor? Thank you very much, everyone.